So, you've heard the term ex parte thrown around in landlord tenant board circles, and now you're wondering if it's some sort of legal magic spell. Well, kind of. It basically allows the LTB to make an order, like evicting a tenant, without notifying the tenant or even holding a hearing. That's right, the tenant might not know what hit them until it's over. When can the landlord pull the ex parte card? This ex parte order is usually in play when a landlord files an L3 or L4 application with the board. Now, what exactly are these forms? L3 application. This is used when both the landlord and tenant have agreed to end the tenancy, like signing an N11, where both parties decide to call it quits, or the tenant has given a notice to vacate, say with an N9 form. L4 application. This one's for when the tenant hasn't exactly kept their end of the bargain. Maybe they've missed payments under a previously issued order, like a prompt payment plan. Basically, if they made a promise but didn't follow through, the landlord can file this one. Once an L3 or L4 is filed, an ex parte order can be issued, faster than you can say, "I need my rent." This order lets the landlord either get the tenant to vacate as agreed or bring in the sheriff to handle the eviction if the tenant's dragging their feet. But wait. Tenants can fight back. No one likes getting blindsided, and tenants do have some legal recourse. They can file a motion to set aside the ex parte order. If they do, the board will then hold a hearing to consider the tenant's arguments. The board will look at a few things like, was there really an agreement to end the tenancy? Did the tenant actually give notice to vacate? Would it be fair, given all the circumstances, to kick them out now? If the tenant has a decent case, the board can lift the order and give the tenant a chance to stick around longer, maybe under new terms. When a hearing is held, if the case isn't resolved ex parte and goes to a hearing, Section 83 kicks in. The board has to review the circumstances to figure out if it should flex its discretion to delay or refuse an eviction. This is where they get to play referee and decide if the tenant deserves a second chance or if it's time to pack their bags. Applications under Section 78 is where things get interesting. If the landlord files an application under subsection 78, the board can evict the tenant and order them to pay rent arrears without even a hearing. Yep, another ex parte situation. But of course, the tenant can file a motion to challenge this, giving them another shot to plead their case. The board will then consider if it's fair to lift the order or if the tenant should be given some relief. Even if the tenant didn't meet the conditions of a previous order, the board could decide to be lenient based on new circumstances. Decisions. If the tenant's motion is denied, the landlord is back in the driver's seat. The board can lift the stay of the ex parte order, meaning eviction day is back on. The landlord can now proceed with enforcing the order, and the tenant may soon find themselves searching for new digs. But there's always room for a little more discretion. The board can delay the enforcement of the eviction if it feels like the tenant deserves a little extra time, similar to how Section 83 gives the board power to delay or deny an eviction. That's ex parte in a nutshell. Whether you're a landlord trying to cut through red tape or a tenant hoping for one more chance, ex parte decisions can change the game quickly. Just remember, there's always a process, and while these orders seem fast, they aren't always final. Like this video and subscribe for more helpful content.